the defense is looking to get counts 1 and 3 dismissed. What is your reaction?
So I'm actually not surprised. Once again, I've said this from the beginning that the defense has had really aggressive tactics towards this particular case. What I find interesting is how they came to have this actual dismissal. And it really came about from independent jurors or information from some of the jurors actually coming forward and reaching out to the attorneys, which sometimes happens, but is not always expected. So I think it's really interesting that on their own, it looks like at least 3 jurors came forward directly to the defense attorney or some sort of informant and expressed their thoughts and feelings on how they would have ruled against some of the charges against Karen Reed. So I'm not surprised that with that information that they received, that the defense team once again went forward and tried to be really aggressive in Karen's defense.
Mm-hmm. Now, when the mistrial happened, it seemed kind of quick. You know, the 3rd letter came in, the judge declared a mistrial. Is it typical that the judge would take a poll of the jury to see where they are since there was multiple charges she was facing, or does sometimes that not happen? What usually happens?
So it's really interesting that it didn't happen in this particular case. There's no defined rule that says that a poll is required to be taken. It really is, again, at the discretion of the judge. In this particular case, and as in many high-profile cases, sometimes just because of the nature of what's happening in the courtroom, it may or may not happen. But I think it would have been useful in this particular case, and we can clearly see why. For a polling to take place. And that just particularly didn't happen in this instance, which is probably why some of these jurors came forward on their own and reached out to the defense team to give their side.
What do you anticipate happening next? I reached out to the DA's office. They said they're looking at the motion and they're going to file a response. Do you think that the information here and these documents is enough for them to drop those charges?
So the prosecution absolutely has to provide a response, as they said. You know, they can't leave this motion here unresponded to. I think ideally what may or may not happen is an evidentiary hearing, which would require some of these jurors to come forward, maybe or maybe not. At this point, their personal names and things of that nature have remained anonymous. And if a hearing were to take place, they would actually have to come forward and identify themselves. So in a perfect world, a hearing would take place, or the judge could just rule on the merits, right? The tricky thing about this is that it is being represented to in an affidavit signed by the attorneys and not by the individual jurors themselves. So it really is based upon the representation that the attorneys received and not from directly from these particular people. So technically, you know, it's considered hearsay. It's not direct personal knowledge. I support the fact that the judge probably will either rule on its papers, but it is a very, very interesting and unique tactic to use by the defense attorney, and something that I'm not surprised that they did in the first place.
Mm-hmm. So the Commonwealth, did they get the final ruling on these motions, or does the judge get a say in it because it was her case and she's the one that declared a mistrial?
So the prosecution will have the opportunity to respond. The judge will review the defense's motion and review the prosecution's motion, and we'll hear from her based upon her decision, right? She may not come out and make an actual statement on the record. She may reduce it to writing. She may call a hearing. It's really hard to say in this particular avenue, but she will come forward and we'll hear what she has to say, either in writing or in the form of some sort of evidentiary hearing or something of that nature. So the Commonwealth doesn't necessarily get the final say per se. They have the right to object, which they will, but the judge is the one that ultimately is going to make a decision on whether to move forward on the papers or to move forward with a hearing on this particular issue.
Mm-hmm. They also had mentioned in the documents, I think, the voyde hearing. So what would that, I know that they did that a few times during the trial. not have the jury present and, you know, do some lines of questioning without them there. So what would that be like in this case with these documents?
Right. So with any kind of voir dire hearing requires the person who is the subject matter in which you're trying to get the information from would come forward and would testify before the court based upon the information that they have. Right. So this is what I was explaining earlier about having the juror or jurors reveal their identity and, you know, actually say who they are, because at this point they've all sort of remained anonymous. So in order to do this actual voir dire hearing, they would have to come forward, identify themselves on the record, and explain what it is that they have told either the defense attorney or an informant, as it's written in the motion, as to the statements that they made and the feelings that they felt during the deliberation pieces, right? So it's a hearing, an actual hearing where testimony is taken from a subject person about the information that they have that they want the court to be aware of.
Mm-hmm. And then how long do you think the judge will take for her to make a decision? How long do you think the paperwork from, you know, the state side will take to be filed?
It's kind of hard to say how long it'll take for the prosecution's office to respond. I would say about a week. That's a generous, you know, amount of time. Could be up to 2 weeks. Again, we don't know what's going on with their caseload, but I don't anticipate too much time. As for what the judge will decide, I don't know. We do have the hearing coming up on the 22nd. So it's very possible that all of this could be heard on the 22nd because it is scheduled for a status hearing as to where the case is going to go. So I wouldn't be surprised if the prosecution filed a response perhaps next week, and then both of the motions either be heard on the motion and the response be heard on the 22nd, or to have an answer by the 22nd, because that's where the case is going to be decided from there.
Mm-hmm. And, you know, kind of like you were saying, you know, maybe kind of reading through the documents. So the judge, like you said, at their discretion can take a poll. So did the judge, from your expert opinion, did they seem to do something wrong in this case, or is it just kind of at their discretion, like you were mentioning?
I think it's really at the discretion of the judge. And, you know, I wouldn't really characterize it as right or wrong. It's something that would have been helpful, particularly in a case like this that is so televised and so, you know, fact heavy, to do a poll of the jurors. I did see in the motion that the defense team was raising the fact that they weren't allowed to ask, or they were kind of kept, you know, the case kind of was moved along to a mistrial, and they didn't have the opportunity to be heard. And all of these are issues that, you know, I've discussed in previous interviews about appeals and the rights of the defendant. So all of this is being notated specifically as to the behavior of what the defense was allowed to do and what the prosecution wasn't allowed to do. So it would be helpful if we had a poll, but there is no hard and fast rule that says, you know, it's a requirement. I think it just would have been nice.
Mm-hmm. And then double jeopardy, it talks about how a retrial on these counts would violate double jeopardy. For someone at home who might not know what that means, can you just go into a little bit of detail of what they're saying in these documents?
Absolutely. So double jeopardy is a constitutional theory that says that once somebody has been tried of a particular crime, that the retrial of that crime is a violation of their constitutional rights. In general, when you have a mistrial, the idea is that no verdict really has come through, right? But what the defense team is saying is that, hey, we have some of these jurors who pretty much unanimously agreed on count 1 and count 3 that they would have not acquitted. I mean, they would not have found Karen Reed guilty of these charges. And that is the decision that they made during their deliberation. And as a result of that, she should not be retried of those charges again, because it would have been a violation of her constitutional rights. So it's a really, really unique argument that they're making here, based upon the representation of these jurors, that they've already made a decision. And that's the key point here. A decision has to have been made against the defendant in order for double jeopardy to attach. And that's the uniqueness of this particular motion that we have here.
Mm-hmm. Is there anything else that you want to add or you think is important?
I think, obviously, to keep watching as this case unfolds. I think it's really important to remember that the jurors in this particular case were the triers of fact. I know a lot of people were making comments about the judge and her influence, but the jurors are really in control of the not guilty or guilty of Karen Read in this particular case. And I think as time goes on, I would not be surprised if more jurors came forward now that we have a few that already have come. And it is in the rules for the attorneys to interview the jurors post-trial. So, you know, I would definitely stay around for more people to come forward.
Mm-hmm. Do you think it's odd that, you know, this is kind of the first time we're hearing from any jurors? They didn't really go and want to be interviewed by the media. They didn't identify themselves. Is that strange? Do you think maybe perhaps because of the nature of this case being so high profile, they didn't want to come forward, or maybe because they knew some of these documents were in the works?
So I said this also before in other interviews, jurors take their jobs very, very seriously. They want to make sure that they're upholding the law, that justice is being served, that they're the ones administering that justice. So I wouldn't call it strange or odd for them to not reach out to the media. And it actually shows the dedication that they have to their juror service, that they're not just looking for a 15 minutes of fame or a book deal or a TV show. They went directly to the defense attorney and expressed some of the concerns that they had, because I would just presume, really do believe, you know, the points that they had against Karen not being guilty as they're purporting to be in this particular instance. So going straight to the source, i.e. being the attorneys in this case, seems pretty typical of jurors who want to uphold the law, who want to make sure that justice is properly served, as opposed to going to the media where it may look like they're just trying to get some sort of, you know, influence for themselves. So I don't find that to be particularly strange. And at this point, technically their service is over, right? Once they were excused as jurors, they technically don't have an obligation to the court anymore, so they can talk to whoever they want. But I think it's well within their right and very interesting and very honorable for them to go to the attorneys and express how they felt about this case.